Hi, everyone. Hello, ready? We start? Good. Okay, where is everyone? Legal writing memo? When does it due? Very, very foolish SIP class. It's not a good idea. I understand the classes are recorded and maybe people can watch them later, but I'm sure for all of you at home watching this now, this was probably a mistake. Once, I did this once, I'm not gonna do it again. I actually wrote something on the board over here. See, I'm off camera now, guys. That was actually useful. I'm not gonna do it again, but or I can just screw up and say, I'm writing something on the board now. No, the reason why I did it was because one person told everyone else, and it was worthless. See, I can't actually trust you to do this. No, that was actually the reason. I actually tried this, and I found out that, oh yeah, so-and-so told everyone on Facebook, whatever, like, okay, so I'm not going to do that again. But you should not skip class unless you have a good reason. I don't particularly care if you're not here, but it's no sweat off my back, but it's for your own loss. Okay. Any questions about last class when we did NFIB v. Sebelius, the Obamacare case? I realize I lectured for nearly 2 hours straight, which I will never do again for the rest of the year. But it's the only conceivable way that I can, much like on the first day of class, for me to pour out as much information as I need to without making the stretch several classes. Any questions on Obamacare? Yes, sir.
Like the dissents and the equal value, like as the majority, like they're all equal. We barely mentioned it. I'm just asking.
What do you mean we barely mentioned that?
I mean, like we had the talk and then we had the discussion.
Well, I mean, I spent length discussing Justice Ginsburg's dissent and the joint dissent. No, we discussed them. So the short answer is with NFIB v. Sebelius, all the opinions are very important because at various junctures, the same justice may be a majority and the same justice may be in dissent. So the controlling opinion, okay, the controlling opinion with respect to the Commerce Clause was actually Roberts, joined by the 4 conservatives. The mandate cannot be sustained by the Commerce power. The controlling opinion with respect to necessary and proper was Roberts with the 4 conservatives. However, the controlling opinion with respect to the taxing power was Roberts with the 4 liberals. With respect to the Medicaid expansion, the controlling opinion was actually divided. 7 justices agreed that the Medicaid expansion was unconstitutional. That's Roberts, the 4 conservatives, plus Kagan and Breyer. However, Roberts, Kagan, and Breyer, 3 justices, and only 3, agreed that the remedy for the Medicaid expansion is to allow states to opt in. How can 3 justices make a majority opinion? Well, Justice Ginsburg mentioned, well, I think it's constitutional, but in any event, I agree that's fine. So therefore, there were 5 justices for that position. So the majority opinions and the dissents are actually fairly poor labels. Depending which part you're talking about, the exact same justice may be majority or dissent. The only person who is in majority throughout the entire decision is His Honor, Chief Justice John Glover Roberts, Jr. But others fluctuated back and forth depending on the issue. Other questions on Obamacare? Yes, sir.
Just curious, this is the majority opinion, the case of the majority. What's the purpose of people now trying to say, we'll repeal that, or how can we do that? If the Supreme Court released this?
Well, the mere fact the Supreme Court says the law is constitutional in no way limits Congress from repealing it. Congress can repeal a perfectly constitutional statute. There's nothing stopping them. It doesn't matter what the Supreme Court. Congress can only change its own laws. Right? I realize, again, lawsuits is a foreign concept, but Congress is free to pass laws and repeal laws as they wish. They don't need the Supreme Court's permission to repeal laws. We'll actually do a case later where apparently the court wants permission to repeal certain laws, but we'll do that later. But generally speaking, legislature does not need Congress permission, the court's permission to do anything. Well, some
Some people may say it's wrong. All right, any other questions on NFIB? Okay. We're changing our direction now. The past 4 weeks or so, we focused on what's often called the structural elements of the Constitution. The structural elements, that's the separation of powers between the state and federal government, and also the separation of powers between the three branches. We've discussed the limits on Congress's powers with respect to commerce, tax, spending, 10th Amendment. And we've also discussed the executive's powers, Youngstown, Dames and Moore, and other cases. For basically the remainder of the semester, we are changing directions to the area that you probably thought constitutional law was about, what's often called individual rights. Now, I think this is a misnomer. I don't like even dividing the topics up, because as we've learned, it was structure of the Constitution that was designed to protect freedom just as much, and in fact, indeed more so, than individual rights. But we begin our discussion today with the 13th, 14th Amendments. Before the Civil War, the Constitution placed very few limits on the states. Very few. I mean, we've discussed them. You know, they couldn't pass a bill of attainder. They couldn't infringe on contracts. I mean, we're talking really limited stuff. Beyond those few bits, the states had their police power. And under their police power, the states could do virtually whatever they want to whomever they want. However, that regime, from the founding of the Constitution until the Civil War, led to certain consequences. Okay? The greatest consequence was a proliferation of slavery. All the Constitution said about slavery was that the slave trade could not be prohibited until the year of 1808, right? The importation of slaves from abroad could not be prohibited until 1808. That was all the Constitution said about slavery. And indeed, many people read provisions like the 3/5 Clause and the Fugitive Slave Clause as tacitly condoning slavery. Note the word slave was never used. They used euphemisms like other persons or things of that nature, right? But the Constitution in no way limited slavery. As a consequence, an entire race of people were chained and shackled and bound in service, and indeed were not treated as human beings, and were not afforded any of the rights provided. We'll discuss in a couple weeks a case I'm sure you've heard of called Dred Scott. I'm going to blow your minds. Dred Scott was a case about diversity jurisdiction. I'm serious. Read it and you're like, wait a minute. The case was about whether a slave was a citizen to sue in federal court. Whether a citizen of Missouri could sue a citizen of New York in federal court. That's actually what Dred Scott was about, believe it or not. But the Dred Scott decision went far beyond diversity jurisdiction. This is why you don't study in CivPro. Went far beyond that. And Chief Justice Roger Taney, who we'll talk about in great length later, stated that people of the African race, not just slaves, but people of the African race, even freedmen, right? There were freed slaves, and indeed there were free blacks in the North. They could not be citizens no matter what. Even if a state, you know, New York or Massachusetts or whatever, decided to afford slaves citizenship, Taney wrote, even if states try and do this, they cannot be citizens. They are not people. And you'll read the decision, and it's very jarring language, but I want you to read it. What overturned Dred Scott, as the book notes, was the case of Grant versus Lee. That is, General Ulysses S. Grant versus General Robert E. Lee. What reversed Dred Scott was not an act of a court, but the American Civil War. The blood spilled at Gettysburg, and other prominent battles. That overturned the Dred Scott decision. We'll talk much more about Dred Scott later, and I almost want to skip over it for now. But as a consequence of the Civil War, the American Congress was in a very unique place. Contrary to what many people may understand today, political parties were quite different. Okay, so Abraham Lincoln was Republican, and for the most part, the southern states were all Democratic. As a consequence of the Civil War, virtually all of the southern states lost representation in Congress. Congress was domineered by the Republicans, deemed the radical Republicans. And they promoted an ambitious and indeed revolutionary legal regime. When people often speak of the founding of the country, they often say 1787, when the Constitution was drafted. You need to add to that period of the founding, our second founding indeed, which was in 1868 with the ratification of the 14th Amendment. This was just as important as anything James Madison or Alexander Hamilton ever did. The ratification of the 13th, 14th, and 15th Amendment indeed were our second founding. And these amendments attempted to correct what those in Philadelphia in 1787 could not do. So I want to walk you through, and take out your constitutions as well, but I want to walk you through the text of the 13th and the 14th Amendment. 15th Amendment we'll get to maybe a little bit later, but I'll do the 13th and 14th for today. So again, these were enacted against a backdrop that virtually all the southern states lost their representation in Congress. So the radical Republicans in Congress could basically propose whatever amendment they wanted. Conversely, many of the southern states were being controlled by what are effectively Reconstruction state legislatures, where the Northerners during Reconstruction installed people to run their governments. And a lot of the southern states actually were not allowed to rejoin the Union until they ratified these amendments. So their validity in terms of whether they had the requisite 3/4 of the states is, a perennial question, but we'll table that. So the 13th Amendment, which was ratified in 1865, this was shortly after the conclusion of the Civil War. Did anyone see the movie Abraham Lincoln or Lincoln? It wasn't very good. I didn't like it. Did you like it?
It was slow.
Yeah, I didn't like it. It was a movie about a constitutional amendment. I didn't like it. That means it was a bad movie. But the movie was about how Lincoln and others were trying to get the 13th Amendment ratified. So the 13th Amendment says, neither slavery nor involuntary servitude, except as a punishment for a crime, shall exist with the United States or any place subject to their jurisdiction. Okay? With that one sentence, the Constitution prohibits slavery. And what's critical here, and I think I mentioned this in the first day of class, the 13th Amendment was the first provision of the Constitution that limited private action. It was the first provision of the Constitution that limited what individuals could do. It doesn't say the government can't have slavery. It doesn't say the state can't have slavery. It says it shall not exist, meaning anyone. Private actors could not engage in acts of slavery. The only other amendment that would ever ban private conduct was prohibition, which fortunately was repealed. But even more so is Section 2 of the 13th Amendment. Section 2 says, Congress shall have the power to enforce this article by appropriate legislation. Now, I've said before that all of Congress's powers are listed in Article 1. Remember Article 1, Section 8, commerce and tax and all this other stuff, right? The Reconstruction Amendments changed that. The Reconstruction Amendments gave Congress new powers to enforce these provisions of the Constitution. This was the radical revolution of 1865 through 1869. No longer did Congress trust the states to ensure that the civil rights of their citizens were protected. That hadn't quite worked out under the original Constitution. So now, Congress was given additional powers to ensure that there was no slavery. Congress didn't trust South Carolina or Georgia to eliminate slavery. Congress could now pass laws. So Section 2 of the 13th Amendment adds to Congress's grants of enumerated powers. And not just that, this isn't about regulating interstate commerce, right, or stuff between states. Now Congress can go into one state and regulate directly within one state without the need. Congress can pass a law. So I'm sure you've all heard of Section 1983, right? You done Section 1983? So a civil rights cause of action. If an individual in a state, right, some sort of state actor, violates your civil rights, you could sue them in federal court. Why? Because under Section 2, Congress made that an offense you could sue in federal court over. It was actually, you'll study 1983 later, but it was originally called the Ku Klux Klan Act, which actually allowed people to go after the Klan through these quasi-governmental officials that lynched people. So this was a significant issue. We'll discuss in a few minutes what that means to ban slavery. Does that mean just literal chattel slavery where people were bound to the land and chained? Does it include racial segregation? We'll get there in a few minutes. Even after the ratification of the 13th Amendment, though, the southern states, as they started gaining their governments back, enacted what were called the Black Codes, or often called Jim Crow laws. The Black Codes try to recreate the institution of slavery as close as possible. They couldn't literally bind people to land. They could not actually bind people to land. However, they made it so it was basically impossible for a freedman. By the way, when I say freedmen, I mean freedmen and women, but they were called freedmen. It made it impossible for the freedmen to actually live on their own. So, for example, they couldn't own property. They couldn't engage in the occupation of their choice. They couldn't make contracts. They couldn't testify in court. Labor contracts had to last at least 1 year. So imagine trying to make a living for yourself if you can't make contracts, you can't testify in court, you can't file lawsuits, you can't hold property. Well, even though you're not a slave, you're basically depending on the mercy of someone else to live. This violation of their economic freedom was the basis of Jim Crow. If people can't live and support themselves and have their own land, have their own property, they can't exist except for the control of someone else. They're indeed what wasn't quite a master in name became a master in substance. At the core of Jim Crow was economic laws. At the core of Jim Crow was denying people the right to have property. Indeed, I always mention this point here, the first gun control laws in America were enacted by Georgia. Why? Georgia didn't want the freedmen to have guns. It makes it much harder to kill Klansmen that way. So among the first acts of gun control in America were attempts to disarm the freedmen. There was actually an entire case called Crookshank, where there was actually in Colfax, Louisiana, if you know where that is, where there was a massacre of these freedmen, of these African Americans in this church, and they basically would not let them have any guns, so they were basically being slaughtered to the death. It was a really sad, if you ever Google Colfax massacre, it's a very sad, sad story. So Congress, though, was furious. Look, we just fought the Civil War. We just enacted this 13th Amendment, and these southern states are enacting these black codes, which effectively treat the freedmen as if they were still slaves. So Congress enacted the Civil Rights Act of 1866. The Civil Rights Act of 1866. And this statute purported to grant the freedmen a host of rights. The statute made everyone a U.S. citizen. Made everyone a U.S. citizen. The statute said everyone's protected by the law regardless of their skin color. It gave people the right to enforce contracts, the right to file a lawsuit, the right to give evidence in court, the right to inherit, purchase, and sell property. If I may borrow from the other class, the bundle of sticks. They got the bundle of sticks, right? They got the full and equal benefits of the laws and basically everything that the white people had. This act was of great significance. It would have afforded the freedmen the full panoply of civil rights that white men Women will get there later, but at least that white men enjoyed at the time. President Andrew Johnson, remember him? Remember the Tenure of Office Act that he vetoed? Do you remember the radical Republicans didn't want to fire the cabinet officials and he vetoed it and we almost had a civil war over that? Johnson vetoed also the Civil Rights Act of 1866. He vetoed it. Why did he veto it? Johnson said it was unconstitutional, that Congress lacked the enumerated powers to grant citizenship in this fashion, and that Congress lacked the powers to tell states how to treat their people. What about the 13th Amendment? Johnson said no. All that does is prevent slavery. It doesn't go any further than slavery. So Congress then was faced with a choice, right? They overrided the veto, right? They overrode the veto, so they enacted the law. But they worried that in some point in the future, the Democrats would regain control of the Congress. As the southern states were admitted, the Democrats would gain control. And they feared that the Civil Rights Act would be repealed by a future Congress. So in order to avoid the repeal of the Civil Rights Act of 1866, the radical Republicans set out again to amend the Constitution, put this beyond the reach of a Congress to rescind, write it in stone in the Constitution, and let them go repeal an amendment. It's a lot harder to repeal an amendment than to repeal a statute. And this gave rise to what became the 14th Amendment of the Constitution. And indeed, I mean, this is probably one of the most significant changes in American law. The 14th Amendment was meant to change everything. Before the 14th Amendment, the states were basically given free rein to do as they saw fit. The 14th Amendment realized that we can no longer trust the states to do that. And it provides certain guarantees for the citizens of the states. And more importantly, it allowed Congress to take action if the states do not enforce them. So let's start by walking through the provisions of the 14th Amendment one at a time, and I will backfill the history as I go along. So the crux of Dred Scott, as I mentioned earlier, was that Africans could not be citizens. Even if they were born in a state that had wanted to give them citizenship, they were not worthy of citizenship. The first sentence of the 14th Amendment rescinds Dred Scott. The first sentence of the 14th Amendment rescinds Dred Scott. It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That is a very powerful statement at the outset. Before the 14th Amendment, there was really not such a thing as United States citizenship. States could grant citizenship. They could hold it to slaves, for example. But there wasn't really the notion that the Constitution said, how does a person become a U.S. citizen? There was naturalization, alienate, but there wasn't a concept of U.S. citizenship. But now, if you were born in the United States, even on a plantation as a slave, if you were born in the United States, you are a citizen of the United States. The subject of the jurisdiction thereof business is interesting. It's always in the news, but one of the issues was about American Indians. And American Indians were largely deemed not subject to the jurisdiction because the reservations were deemed sovereigns unto themselves. And there are often questions, and this is one of Donald Trump's favorites, whether the children of people who are immigrants are citizens. And this question perpetually reigns. From my best reading, even the children of immigrants would still be subject to the jurisdiction of the United States. And this debate has been going on for 100 years. It will never stop. But my reading is I think it's okay. But more important than federal citizenship, they're not just citizens of the United States. They're citizens of the state wherein they reside. This is pivotal. Not only were they now U.S. citizens, but a slave born on a plantation in Georgia, now you're not a slave anymore by the 13th Amendment. And oh, by the way, you're a citizen of Georgia. that now Congress through the Constitution was requiring the states to vest those born in their states with citizenship. Why is this significant? Because once a slave had state citizenship, he was entitled to all these privileges and immunities we discussed before, right? I forgot to put it up there. If you turn to Article 4 of the Constitution, I forgot to put it up there. I should have. My mistake. If we turn to Article 4 of the Constitution, it's on page 33. Article 4, Section 2. It says, the citizens of each state shall be entitled to all the privileges and immunities of the citizens in the several states. These privileges and immunities refer to a lot of so-called civil rights. The right to give property, the right to sell, the right to, basic building blocks of society. We'll discuss later exactly what they are. But once you were deemed a citizen of a state, you were entitled to these privileges and immunities. This is why Dred Scott could not deem an African, even a freeman, a citizen, because then they get these rights. And to Tawney, they could not conceivably get these rights. So by this first sentence, if you were born in the United States, you are now a citizen and get all these rights attached to them. All these rights of the states. Okay? But they didn't just get rights of the state citizenship. Congress did more stuff. Okay? So the second sentence, actually the second sentence is a long sentence. But the first part of the second sentence defines what those rights were. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This was supposed to be the crown jewel of the 14th Amendment. If you look at the drafting history by John Bingham of Ohio and others, they deemed the privileges or immunities clause as the thing that will provide civil rights for everyone. I want to just note quickly, if you flip back to page 33 in your Constitution, in Article 4, it's privileges and immunities. Privileges and immunities. In the 14th Amendment, it's privileges or immunities. Everyone see that? In Article 4, it's privileges and immunities. In the 14th Amendment, it's privileges or immunities. The grammatical difference, I've never found a good reason why they're different. I'm not sure. I've researched this. But don't confuse them. If I say privileges and immunities, it's Article 4. If I say privileges or immunities, it's 14th Amendment. And the way you can remember this is and, A comes before O, or. So it's first and then comes or you can memorize it however you want, but don't get them confused. It's a pet peeve of mine. Law professors get them confused, so it drives me nuts. They're different clauses. But these privileges or immunities were meant to be this huge font of rights. And in order to give content to this, many scholars believe that we should look to the Civil Rights Act of 1866. Because if you think about it, the Civil Rights Act of 1866 gave the freedmen all these various rights. And the Congress was worried that some future Congress could repeal them. So one of the leading theories, and the one that I subscribe to, but by no means it's correct, is that Congress attempted to constitutionalize the Civil Rights Act of 1866. That Congress attempted, through these privileges or immunities, to give citizens these rights that the states could no longer infringe upon. These include the rights to make contracts, to pursue an honest living, to hold property, to be a witness in court, certain foundational building blocks that are really essential for a person to be free in a society. Okay? I'll give you a preview, though, of what comes later. What about the right of free speech? What about the right of freedom of religion, free exercise? What about the right to keep and bear arms? Are these privileges and immunities? So the short answer is we'll do this later. But many of the people who ratified the 14th Amendment believed that by virtue of the privileges or immunities clause, the Bill of Rights itself will be extended to the states. Recall, the First Amendment says, Congress shall make no law. Congress. says nothing about the states. So there are many people, and I again subscribe to this theory, who believe that the 14th Amendment's Privileges or Immunities Clause was meant to extend or incorporate the provisions of the Bill of Rights of the states. So no longer could the state shut down an African American newspaper. No longer could the state disarm the free blacks. That the first 8 amendments of the Bill of Rights were indeed extended through the Privileges or Immunities Clause. Give you a preview. Only Justice Thomas has ever adopted that theory. He's right. The other justices did it in a different way, which we'll discuss later. But the idea was these substantive rights, these liberties, these privileges or immunities included at least what was in the Bill of Rights, and I think I would also add the Civil Rights Act of 1866. Okay? I'll keep reading. The next clause, so starting at the semicolon, you might want to just in your book just separate, or in your Constitution just separate them, because they're 3 separate clauses. They're not all the same. The next one says, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, you probably realize this phrase is familiar. It's in the Fifth Amendment. The Fifth Amendment binds the federal government. So before 14th Amendment, the federal government cannot deprive someone of due process of law. The states could. So at a minimum, the Due Process Clause was meant to provide the same procedural protections that the federal government was bound by. Now, to fast forward also to your preview, the phrase liberty in that clause has taken on a life of its own. And indeed, the court has held that some of the liberty interests protected by the 14th Amendment include things like access to contraceptives, access to abortions, and indeed last year, the right to same-sex marriage. So that the phrase liberty is what's called substantive due process, the idea that this liberty as a substantive component has expanded. And the reason why substantive due process has expanded so is because of the Slaughterhouse case we'll do in a minute. You see, this clause, this Privileges or Immunities Clause, was slaughtered by the Slaughterhouse cases to the point where the clause meant nothing else. So the court shifted the next sentence over to, all right, can't be PRI, got to go to due process. So what we'll study, again, this is more of a preview, is that the reason why the Due Process Clause has gotten so much attention is because the Privileges or Immunities Clause was strangled in its crib by the Slaughterhouse court. The third provision is the one most of you probably have heard of. And perhaps to your surprise, it was considered the least important one. Last. Nor shall any state deny to any person within its jurisdiction the equal protection of the laws. Now, you may think, well, that's so obvious. Like Brown v. Board, that means you can't have segregated schools. Well, it's not entirely clear what that state or what that law meant. For example, if you passed a law saying blacks go in this train car and whites go in this train car, well, you're applying the law equally. Blacks can go here, they can go there, and whites can go here, they can't go there. Indeed, there was lots of arguments that the Equal Protection Clause didn't actually demand colorblindness, as we'll see in later cases. That the doctrine of separate but equal is actually premised on the reading that as long as you have equal accommodations and they're enforced, they can be separated. The lesson you'll learn from today's class is that all of the great things that were perhaps intended or implied by the 14th Amendment didn't happen. The Privileges or Immunities Clause was basically slaughtered by the Slaughterhouse case. Equal protection was basically diminished by the Plessy v. Ferguson decision. And the Due Process of Law Clause didn't get any teeth until about 70 years later. So after the bloody Civil War in the case of Grant versus Lee, and the efforts to fundamentally transform the Constitution, in part due to the Supreme Court, though it's not entirely their fault, things didn't change as much as perhaps one would have anticipated upon the ratification of these amendments. So does anyone have any questions on Section 1 of the 14th Amendment? I realize I haven't stopped for questions. I have a lot to get to today. Luis.
So who has the power to say whether you were actually born in the country, the state or the federal government? Because I can see, like, if somebody is born in the house or something, and he's born and he's black, and so then the state says, oh, I'm not going to recognize that person as a citizen of the state because he's black. So I'm just not going to say that he's born here. There's no proof that he was born here.
Well, the question then is, what happens, say, for example, that Georgia or whatever passes a law saying that if you're black, you're not actually born, right? What are the remedies at that point, Luis?
I'm not sure I got my question.
Say the state passes a law providing that if you're black, you're not actually born in the state. What are the remedies for that individual? What are the remedies? What can what can happen? Two things I can think can happen.
If you're black, you're not a citizen.
Yes, but what can you do? What does the 14th Amendment now allow to happen? Before the 14th Amendment, if the state had passed a law, the person would have no remedy. After the 14th Amendment, what can happen?
You sue because the law is unconstitutional.
And what gives you the right to sue? Which section? Five. Section 5 of the 14th Amendment, much like Section 2 of the 13th, gives Congress the power to enforce this provision by appropriate legislation. You don't think about this, right? But you say, oh, I'm going to go sue. Why are you suing? Because Congress created a cause of action. The only reason why you can go to a federal court and file a lawsuit is because Congress let you. Unless Congress creates a federal cause of action, you can't sue. So indeed, Luis, Congress passes a law, the Ku Klux Klan Act that I mentioned a minute ago, that if a state official acting under the color of state law deprives you of your 14th Amendment rights, what can you do, Luis? You sue them. And now, because there's federal court jurisdiction, a federal judge can say, wait a minute. The Constitution says if you're born here, you're a citizen. You're making this law that says if you're black, you're not actually born. This law is stupid. Your state law is unconstitutional. Give them a birth certificate. So the 14th Amendment inserted both Congress and the judiciary into the enforcement of civil rights laws within the states.
So then it's a question of fact for the court to say if you're born in that state.
You insert a judicial remedy? Exactly. This is how civil rights laws work. Congress creates these causes of action which allow private actors to sue, saying, hey, there's a state official who won't give me my birth certificate, even though I was born in the state. Injunction. Give them an injunction. Require them to give me this certificate. Yeah.
So, from what I'm getting from it, I think that Congress is doing this to get another gateway to interfere with federalism power, or the separation of power between federalism and the state, or federal power from the state, and that they can kind of spin something into a 14th Amendment issue, and it kind of supplements the things that we were going over last class with.
So let me answer your question a little different way. You said that this allows them to interfere with the separation of powers.
Well, just they can regulate it through this.
That was the purpose of the 14th Amendment. You see,
Right.
the 14th Amendment reflected a recognition that, okay, the old system wasn't working. We need to have further federal intervention to state matters. So it's not that they're interfering with the separation of powers. It's the 14th Amendment invited Congress to do that if the states were not adhering to the new amendment, right? This, again, radically altered the relation between the state and the federal government. This was meant to interfere, to use your word. Yeah, Tariq.
So you would say that Congress have the power to do this. So is this power limited? And
Oh, yes, such a good question.
only state?
Such a good question. Yes, indeed, Congress's power under Section 5 is limited. That's the civil rights case we'll do later today, wasn't it? The civil rights case said Congress can't reach private action. And we'll do other cases. For example, we did United States versus Morrison, the Women Act case. That wasn't just a Commerce Clause case, also a Section 5 case. I'm sorry. When I say Section 5, understand I'm talking about Section 5 of the 14th Amendment. I'm going to use that abbreviation. I'll just say Section 5. I'll expect you know what I mean. But I'll just say Section 5 versus Section 5 of the 14th Amendment, also called the enforcement power. Okay, everyone with me so far? Let me run you through quickly the other provisions of the 14th Amendment before I move on. Most people never get past Section 1, but there's good stuff in Section 2. Section 2 repeals the Three-Fifths Clause. Section 2 unequivocally repeals the Three-Fifths Clause. Look what it says. Representation shall be apportioned among the states according to the respective numbers, counting the whole number of persons in each state. That means not 3/5. That means whole, 100%. Three-Fifths Clause is repealed. The states would now have population based on the African Americans. In fact, in one of the first amazing acts, there was actually an African American senator. I can't remember what state. It might have been Georgia. I can't remember. There was actually an African American senator elected shortly after Reconstruction. This is before the black codes kicked in, but they actually did a new population. Were able to vote in a black senator, which is stunning. But that was short-lived. There would not be another one for a very, very, very long time. The next sentence says, when the right to vote is limited based on race, right? When the right to vote is denied to any male inhabitants who are 21 years old, okay, the state loses representation. What does that mean? They haven't enacted the 15th Amendment yet. They haven't said you can't discriminate against the right to vote. But they've said, if you go ahead and deny blacks the right to vote, we will cut your state's representation. In other words, you lose members of Congress. Note, though, and for those reading minor Happersett later, it says male inhabitants. It makes clear that the right to vote seems to be limited to male, which undercuts the argument later that the women were allowed to have a right to vote based on the 14th Amendment. Okay, move on to Section 3. This provision is interesting. If you had engaged in insurrection or rebellion against the United States, you can't hold office. Right? If you had actually engaged in insurrection against the United States, you can't hold office. What was the purpose of this provision? To prevent the former Confederate leadership from being elected to Congress. He wants to keep them out. Makes sense, right? But effectively, it was a political test where you couldn't hold office if you engaged in rebellion. Section 4, yes, sir.
So was that, you can't hold office, was that at the federal level or the state level or both?
Federal. Section 4, this provision doesn't come up very much, but I want to mention it. So I'm about to blow your minds again. So we all discussed the Emancipation Proclamation. Very few people know what it actually was. So during the Civil War, believe it or not, a lot of the northern states allowed slavery, Maryland, Kentucky, and otherwise. This wasn't a north-south issue. During the Civil War, President Lincoln issued the Emancipation Proclamation. Now, what we're all taught in school was that the Emancipation Proclamation freed the slaves. That's only half right. It only freed the slaves in rebel territory in the southern states. But that's not even completely right. How did Lincoln go about freeing the slaves? So blow your mind. During wartime, the commander-in-chief has the power to seize rebel property. For example, say the Northerners conquered a fort in the South. They can then take the property in the fort, take their cannons, take their guns, whatever else, and use it for their own booty, right? Lincoln announced, as commander-in-chief, I am hereby seizing the Southern property, including their slaves. Whoa, right? Lincoln seized the Southern slaves as property under the commander-in-chief power. He then immediately, as the owner of that property, freed them. He emancipated the slaves he had just seized. That's not what we were taught in school, was it? But what's interesting is what happens when the government seizes property? They have to pay just compensation. So there was actually, I'm not joking, there was actually an argument that the Emancipation Proclamation was the taking of private property without compensation. The same way that Truman seized the steel mills. Wow, right? The same way that Truman seized the steel mills without compensation. There was an argument that Lincoln violated the Constitution by seizing the slaves without compensation. So what the 14th Amendment says? Neither the United States nor any state shall pay any debt incurred blah, 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 for any claim of the loss of emancipation of slaves. The 14th Amendment expressly says, our bad, right? Lincoln probably seized the property without paying for it. We don't have to pay it. I promise you, none of your classes will ever read that provision of the Constitution, but it's a fascinating history. They were actually guarding against a takings claim. And I mean, I looked at the number once. Like, if you actually adjusted for inflation, the number's in the billions of dollars, right? Like, there were billions of dollars. That, I mean, as grotesque as it was, they could calculate the price of a slave. I mean, this is something you put a price on a head. So actually, slave masters were actually bringing claims in court to try to recover the value of their freed slaves. So this provision nullified that. I mean, it's jarring to think about, but this was a practical document among other things. Okay, and this brings us back to Section 5, that Congress can enforce it. Okay, before I go into Slaughterhouse, does anyone have any questions about the actual text of the 14th Amendment or the 13th Amendment? Yeah, I don't know if that Truman cited the Emancipation Proclamation in his support for seizing the steel mills, but he could have. He could have. I mean, it was a wartime seizure of property, wasn't it? Yeah, think about it for a second. Any other questions before we move on to Slaughterhouse? Okay, very good. So the Slaughterhouse case is an interesting one. So as I mentioned before the 14th Amendment, the states had a police power. And the police power was considered virtually unlimited, right? The states could do whatever they wanted to promote the health, safety, and welfare of their people. They had unlimited police power. But then the 14th Amendment came along, and it put some limitations on the police power. What were those limitations? Bizarrely, the first two cases to consider this were not involving slaves, not involving segregation. They involved a law concerning health at slaughterhouses and the admissibility of a woman to the bar of Illinois. These were, odd first cases to understand this brand new amendment. And this part I'll say with great certainty, the Slaughterhouse case was wrong. This is something which virtually every law professor agrees on. Not everyone, but maybe one or two accepted. The court screwed up the Slaughterhouse cases. The court gave the Privileges or Immunities Clause such a narrow interpretation so as to render it virtually irrelevant. The court read it so narrowly to render it irrelevant. So, and I'll lecture a little bit more because we have way too much to do today. The facts of the case were like this. The city of New Orleans, perhaps as is today, had hygiene problems back then. And they had a massive problem of infection and disease and rot at their slaughterhouses. So the city came up with an idea. And the idea was this. Instead of having all of these little slaughterhouses, where they kill animals throughout the city, we're going to have a single slaughterhouse. And this is actually a wood cutting of the Crescent City Slaughterhouse Company. Imagine it's like this long row where basically animals are led through. They're chopped up after, as they go along. It's gross. But the thinking was, if we have one single place where all these animals can be slaughtered, then we'll deal with the hygiene problems. So the act effectively criminalized someone from opening up their own butcher shop. And they said you can only bring your animals to be slaughtered in this one location. And oh, by the way, the law gave the exclusive privilege to a single company, the Crescent City Slaughterhouse Company. And oh, by the way, the law shut down all private slaughterhouses. So this raises an interesting question. This is a monopoly, right? I mean, you haven't taken economics, but this is a monopoly. The government was giving to this one company a complete monopoly on this business. And anyone who wanted to compete could not at the force of law. Now, how do we understand this law, right? On the one hand, you say, well, they're trying to ensure, safer conditions and better sanitation. But what's interesting is the law said absolutely nothing about how the slaughterhouse, the big one, was to be maintained. There was absolutely nothing in the law concerning how the slaughterhouse had to be maintained. All it said was this one company gets a monopoly. So imagine if you were a butcher living in New Orleans at the time, and you said, wait a minute, I've been a butcher for 20 years. My shop is clean. What right do you have to shut down my shop? Right? Come in and inspect my shop, right? Tell me to keep it cleaner, but don't shut down my business. This is my livelihood. This is where my family gets their business from. So before the 14th Amendment, the butcher would have had no argument. The state's police power was unlimited. But after the 14th Amendment, the butcher had an argument. He says, well, one of the privileges or immunities is my right to earn an honest living, is my right to make contracts, the right to run a business, right? Who the heck are you to tell me I can't run my business? Come in and tell me if it's not clean or not, but you can't tell me I can't run a business of my choice. It's a lawful profession. So the butchers brought suit under the 14th Amendment, and they argued that this Louisiana butcher law violated the privileges or immunities of the butchers. Okay? What the court does next, and the majority opinion by Justice Miller, is an act of judicial homicide. The court's opinion, and I don't say this often, is egregious. Not even a decade after the conclusion of the Civil War, the court seeks to minimize this clause beyond any recognition. So despite this lengthy history of discussions of how this would include the Bill of Rights, this would include the rights to make contract, the rights to own property, the right to pursue an honest living, the right to free speech, despite all these hopes of the Congress that this privileges or immunities clause would afford people bedrock civil rights, the court says no. The court says no. They said that all the 13th and 14th Amendments were done. The purpose of the 13th and 14th Amendments was to eradicate slavery. And I'm not exaggerating much when I say once slavery was gotten rid of, well, job's done. Let's go home, folks. Pack it up. We're good. They read the 13th and 14th Amendments to basically eliminate just slavery and not much else. This is an almost facetious understanding of the Reconstruction Amendments that followed the Civil War. That if this was what we fought a Civil War over, it was a wasted effort. The court even says the event's almost too recent to be called history, but they read it very narrowly. So then what are these privileges or immunities of citizenship? Well, let's look at the text. And there's actually a textual argument here, which is wrong, but at least try and make a textual argument. The court says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So how does the court read this? This is actually their key move. They say, we're not talking about state citizenship here. We're talking about federal citizenship here. These aren't state constitutional rights. They're federal constitutional rights. So what are these federal constitutional rights? And it's here that the court goes entirely off the rails. I'm going to list them for you. We fought a civil war to guarantee the privileges and immunities, to include the right to come to the seat of government, free access to seaports, access to sub-treasuries, access to land offices, My favorite, protection on the high seas. The right to the navigable waters of the United States. To the court, we fought a civil war so that American citizens can now access the Treasury Department, a bank, if you will. So that American citizens can now have access to protection by the Navy on the high seas. Yeah, I mean, when I say they strangled the Privileges or Immunities Clause in its grave, I am not exaggerating. These lists of rights are pathetic. If you read the debates over the ratification of the 14th Amendment, and again, this is mostly geared upon, there are a couple of scholars, Kurt Lash, among others whom I respect deeply, although I profoundly disagree with them, who take this position, that this clause was meant to protect so little. They also say, well, you know, there's no due process violation, right? There's no liberty interest at stake. Well, equal protection, no, that was meant for an emergency at the time, right? Equal protection doesn't apply anymore. There's no more slavery. The court read this clause so narrowly, and we'll see in the next case, the Bradwell case, even more narrowly, that basically it was dead. After the majority opinion in Slaughterhouse, and then in Bradwell a couple hours later, it was decided the next day, I think, or the next week, it was very close in time, the Privileges or Immunities Clause would basically be a dead letter. A couple of justices here and there would write about it. But it wasn't until Justice Clarence Thomas in 2010 who wrote a decision that I find quite persuasive. The issue at hand was McDonald v. City of Chicago. The question was whether Chicago, the city, was bound by the Second Amendment, whether Chicago could ban private ownership of handguns. And Justice Thomas wrote a very powerful opinion stating that among the privileges or immunities of citizenship is the right to bear arms. And because Chicago, part of the state of Illinois, cannot deprive anyone of that right, the Second Amendment extends to the states. But other than that decision, PRI became basically a dead letter. What we remember most about Slaughterhouse was a dissent from Justice Field. Justice Stephen Field writes that this act was a naked case. What does that mean? This was an act of protectionism. This was not an act to protect health and safety. This was meant to give a monopoly to the good old boys from Louisiana who were friends with the mayor or whatever it was, right? This was meant to give a monopoly. If anyone's from Louisiana, it's still like that today. Not much has changed in 100 years. This was a kickback to the mayor's buddies and chums. And Justice Field writes that if in fact the majority is right, the 14th Amendment was a vain and idle enactment. Justice Field cites the 14th Amendment's predecessor, the Civil Rights Act of 1866, which guarantees the right to enforce contracts, to sue, to give evidence, to inherit property, to sell property. There was a meaning, right? This phrase, privileges or immunities, had an established meaning, Justice Field says. And the court just ignores all of that. There's also a dissent by Justice Bradley, who lists a number of these rights, as well as Justice Swain, discussing that labor is a liberty interest that should be allowed to enact. Okay, so any questions on the Slaughterhouse cases? It's difficult teaching this because it's wrong, but at least you understand, I think. Virtually all scholars agree it's wrong. There are a couple who don't, and their opinions are respected, but my opinion is it's quite wrong, based on everything I've studied. But yes, three.
If the decision was wrong and we have the final exam, can we use that decision?
It's good law. It's good law. It's good law.
So when are we free to use dissent? When should we use dissent?
You can always cite a dissent. If you think the dissent's more persuasive, you're always free to cite the dissent. This is why your books have dissents, because they're often better. Right? Who am I to say a decision's wrong? I'm just, some guy up here on the stage, right? What do I know? I'm not five justices. What do I know, right? This class isn't just about your exam. There's deeper stuff than your final exam, although that is certainly important, but this class goes a lot deeper than that. Yeah.
Are you saying this hasn't been expressly overturned?
Nope. Chicago handgun case that I mentioned a few moments ago, the petitioners, actually a lawyer named Alan Gura, who's now my co-counsel in another Second Amendment case, the petitioners expressly asked the court to overturn Slaughterhouse. The court did not take it up. The majority basically said, well, it's been there for a while, no sense upsetting the apple cart. And the dissent said, yeah, maybe they have a point, but whatever. And only Justice Thomas would have expressly overruled it. Yeah, for all that Justice Thomas gets negative attention, and I mean, he gets way too much, his opinions are among the most thoughtful and thought-provoking, and that he often has to force people, because when you make an argument, the other side says no rebuttal to you, right? You make an argument, the other side says, yeah, whatever. That's not a response, right? That's almost like a forfeiture. If you have a sporting game and you show up and the other side doesn't even show up, you win. So very often when you make an argument the other side has no response to, even if it's not overturned, it speaks volumes. Any other questions, Slaughterhouse? Yeah, Marissa.
Is Thomas ever since then said, why is this offensive piece of law still does he still continue to push that he should honor this?
So what's interesting is something called the perpetual dissent, right? And this is fairly coming up. So for example, this is Marshall and Brennan thought the death penalty was unconstitutional in all of its regards. And in every single case involving the death penalty, they would dissent saying this is unconstitutional. It's what's called a perpetual dissent, even though they're still in dissent, right? They keep doing it. I don't know if there's one or two cases where Thomas mentioned the subsequent to McDonald's, or maybe one or two cases, not a lot, but it doesn't come up very often. It does not come up very often. It's a fairly obscure clause. Okay, Clayton.
Yeah, how have regulations that are so crippling to business have not been challenged? Would they just be upheld on other ground?
So we'll do a case in about 2 weeks called Lochner versus City of New York. This is perhaps the most famous or infamous, depending who you ask, cases involving a New York law that limited the number of hours that could be worked a week. And this case was challenged not under the Privileges or Immunities Clause, but under the Due Process Clause. And we'll get there. But the short answer is the New Deal rescinded that and said that economic regulations are not subject to any meaningful challenge. But we'll get there in a few weeks. Any other questions on Slaughterhouse? No? Okay, let's move on. So the next case, Bradwell versus Illinois. Yeah, that was it. It was decided the day after Slaughterhouse by the same author, Justice Miller. And what's interesting about this case, and again, the facts of the case are such that a woman, there was no law school back then, right? Law school didn't exist. That wasn't a thing. In fact, most justices never actually graduated from law school. Justice Jackson, the great one, right? He never even graduated from law school. He went for 2 years. It wasn't necessary. Most lawyers came to the bar through an apprenticeship. They would work for a lawyer. It's called reading law. And they would work for a lawyer for a number of years. In fact, Virginia, where I took the bar, still allows that. You have people who never went to law school can sit for the bar. So Ms. Bradwell, I think her husband was an attorney, and she worked with him for a number of years. And then she wanted to go apply to the Illinois bar to sit for the bar exam. And the Illinois Supreme Court told her, no, you can't do this. Okay. What's interesting, and this is mentioned afterwards, is Illinois subsequently changed the law to allow her to sit for the bar exam, which would have mooted the case. So unclear exactly why. The second thing that makes this case interesting is it was basically decided at the same time as Slaughterhouse. Had she brought the case after Slaughterhouse was decided, she would not have hinged her entire case on privileges or immunities. She may have tried to hinge her case on the Equal Protection Clause, right? Discriminating against women. But she thought, as most people did, that PRI was it. That, right? It guarantees your right to a living. If I want to be a lawyer, then you can't tell me not to. That was the gravamen of her complaint. The other interesting thing about this decision was Slaughterhouse was 5-4, right? It was sharply divided. Bradwell was unanimous. It was 9-0. And it creates an odd situation for the justices who dissented in Slaughterhouse, who now have to vote again. So just the day before, they said that the Privileges or Immunities Clause guarantees these fundamental liberties, right? So then how do you go around the next day and say, oh, but not to women? Well, they said exactly that. They said an opinion which always makes students wince. And Justice Bradley's concurring opinion with Swain and Field, let me get it. Man is or should be women's protector and defender. Natural and proper timidity and delicacy of female sex are unfit for many occupations of civil life. The harmony of family is repugnant to the idea of women adopting independent careers. And indeed, you'll study this in property later, but there was this notion of coverture. Have you mentioned this yet? Under the law, a married woman ceased having an independent legal existence. A married woman and her husband formed a new person. It's called a common law union. And whatever property the single woman had goes to this fiction. And whatever property the woman inherits goes to this new collective. The reason why it's called coverture was the man literally covered her, that he took care of her. But as a consequence, only men can make the decision of how property was used. So indeed, married women had no right to inherit property. They had no right to sell property. They could not make contracts. Indeed, they couldn't even earn wages, which is interesting. They legally, any wages a woman earned would be given to the husband. So this was actually Ms. Bradwell. I found a picture of her somewhere. And there's actually a picture of her later in life. Perhaps the one plus side to this case is what happened afterwards, that Congress enacted a law allowing women to approach the federal bar. They could go to the bar of any federal court. And in 1892, the Attorney General, which is it's a big deal, the Attorney General moved for the admission of Ms. Bradwell to the bar. Subsequent, there's actually a book, if you want to read it, called America's First Woman Lawyer, about Ms. Bradwell. And subsequent to this, she became a newspaper editor. I don't know if she ever actually practiced law, but she may have on the side. But she became an editor of a Chicago legal newspaper, which was the first newspaper, a legal publication published by a woman. And I found a couple copies of one from the Library of Congress over here. I don't know who drew on it, but it says Myra Bradwell, editor. And this is actually cool. There's actually a letter at the Library of Congress from Susan B. Anthony to Myra Bradwell saying, like, congratulations, good job. And you can read that later. It says, hold on. I can't read it. The first legal paper edition of a newspaper, Myra Bradwell. I can't read the rest of it. It's too small. But this was Susan B. Anthony's pen. Okay. So we'll do later on in the semester gender jurisprudence. That is discrimination on the basis of sex. And it wasn't until the 1970s that the Supreme Court began reading the Protection Clause as prohibiting certain forms of sex discrimination. But the Bradwell case in 18 whatever it was one of the first instances where they said, you know what, privileges or immunities, that doesn't get you very far. That will not get you the right as a female to work in a court. You raising your hand? No, I thought he was. All right, questions on the Bradwell case? Yeah, I don't like lecturing, but today the readings are too heavy, and I like getting through stuff. Questions on Bradwell? No? Okay. The next case is also very interesting. It's a case of Minor versus Happersett. Minor versus Happersett. And this involved the right of women to vote. Now, this is actually a picture of Virginia Louise Minor, who is the individual question in this case. So I mentioned this earlier, but the 14th Amendment, I'm sorry, after the 14th Amendment was ratified, the 15th Amendment was ratified. If you look in your constitutions, page, right? Amendment, page 50, 50. 15th Amendment says, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on the account of race, color, or previous condition of servitude. The Congress shall have the power to enforce this article by appropriate legislation. Okay? So even though the 14th Amendment, recall Section 2, I'll show it to you again. Section 2 said if you deny any male inhabitants over the age of 21 the right to vote, then you lose representation. Unsurprisingly, the southern states didn't care, and they still blocked black males from voting. So the 14th Amendment says very clearly, 15th says the right to vote by the United States or the states, right? States can no longer block the right to vote by race, color, or previous condition of servitude. That means former slaves. And oh, by the way, Congress has the power to enforce this. So if you've ever heard of the Voting Rights Act, that law is enacted based on Section 2 of the 15th Amendment. That gives Congress the power to do this. That gives Congress the power to monitor polling places and do these various sorts of things. However, it says nothing in the 15th Amendment about gender. It says nothing about not denying the right to vote based on based on your sex. Now, there's actually a story that's true. And I mean, this is actually a true story. So Susan B. Anthony, one of the great suffragists, one day she was in New York and she walked into a polling place and she's like, I want to vote. And they said, you can't, you're a woman. She takes out her constitution as well. It says, nor shall state deprive any person, right? Nor shall state deprive any person legal protection of the laws. She said, it's person, not man. It's person. They said, okay, we'll give you a ballot. And the story is she was allowed to vote. That didn't catch on. Because as we'll see in Minor versus Happersett, the question was, are all citizens voters? So there was no doubt that all women became citizens, right, by virtue of the 14th Amendment. They were citizens, no doubt. But the court says, does that include the right to vote? And the court has two main textual arguments, right? The first main textual argument is the 15th Amendment. If black males needed an amendment to vote, so do women, right? If you needed an amendment to prohibit states from banning racial discrimination, you would need another amendment concerning gender discrimination. The second major argument concerned the 14th Amendment itself. It explicitly references depriving representation for males, right? It doesn't say anyone, it says males. So the presumption was females were still cut out. The court says, had the framers wanted to give women the right to vote, they certainly could have, right? There was actually a suffrage movement going on, some relics of it. But in 1848, there was a famous document by Elizabeth Cady Stanton called the Declaration of Sentiments, which was supposed to be a declaration of independence for women, enlisting a whole host of rights, among which that women can get divorced, women can inherit property, and these sorts of things. So there indeed was a suffrage movement going on at the time of the ratification of the 14th and 15th Amendments. And here's some suffragettes from the 1920s as well. They're called suffragettes. People who want suffrage. So the court rejected this, and they said that you will not get the 14th Amendment to cover the right to vote. Okay. What happened later? Well, another 40 years later, in 1920, Congress ratified the 19th Amendment. And if you look forward and you go to page 52, it now says the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on the account of sex. There you go. So you need an explicit amendment. It took a couple decades, but they got it. And a later amendment expanded the suffrage further. The 24th Amendment on page 56. It said the right to vote shall not be violated by poll taxes, which was actually a surprisingly big deal back in the day. You'd have to pay to vote. And the 26th Amendment says the right to vote cannot be denied to people under the age of people over the age of 18. So it gave a bunch of college students the right to vote, wisdom of which is still under review. Mostly joking. So the suffrage has been granted at various points by the 15th Amendment, by the 19th Amendment, by the 24th Amendment, and by the 26th Amendment. Okay. All right. Any questions on the Minor versus Happersett case? Yes, ma'am.
So if the 13th Amendment essentially calls people who are still in prison, it's essentially saying they're still in servitude, and then the 15th Amendment says that the states in the U.S. they can't block anyone from voting based on prior servitude. Shouldn't someone who's previously been convicted of something still be able to
What a
vote?
good argument. What a very good argument. Okay. So if you read the 13th Amendment, actually, I didn't mention this, but I ought to. It says neither slavery nor involuntary servitude, except as a punishment for a crime where a person has been duly convicted. If you think about it, right, if you're a prisoner, you can make the argument that you're a slave. You're stuck in a cell and you can't leave. So the 13th Amendment says except for being duly convicted, so that means you're not actually a slave. This is why things like chain gangs, which if you ever saw that movie, Oh Brother, Where Art Thou, right? Chain gangs are very prominent. And you could basically keep someone as a slave because they've been convicted for a crime. Now, this is actually a good segue into Strauder, but very often blacks were arrested for things like vagrancy, right? Stupid, trumped up crimes that don't mean anything. And that allowed them to be thrown into jail and put into a chain gang. So they were effectively enslaved for periods of time. And because the juries were white, they were being convicted. So the short answer is the 15th Amendment doesn't give people in prison the right to vote. Now, a better question is what happens after you get out of prison to get your vote restored? And this is an area of law that's actually very surprisingly complicated. States have different approaches to restoring voting rights. Some give it automatically. In some states, an ex-felon must petition for it. In other states, you can't get it back, period. I've written about this elsewhere, but it's not clear to me how you can be perpetually denied a constitutional right after you've, in fact, served your time. I'll get to you in a second, Mirza. So you may have seen the news the other day that Justice Thomas asked a question which made a big fuss. But far more important than the fact that he asked the question is what he asked. Indeed, he's always pushing the boundary. So the case involved a very esoteric concept. A person had been involved in an act of a domestic violence where he was convicted for a misdemeanor. Okay, not a felony, but a misdemeanor, right? Less than a year in jail, whatever it was. As a consequence of being convicted for this misdemeanor, under federal law, the person was effectively barred from owning a gun ever. And what Justice Thomas asked the U.S. attorney, who did not see this one coming, what other constitutional rights can you deprive someone of because they commit a misdemeanor, right? Can you deprive someone of the right to vote indefinitely because they committed some sort of stupid crime before? Can you deny someone the right to publish a newspaper if they've been convicted of child obscenity before? Could you deny someone the right to bear arms because they've been engaged in some sort of act of violent misdemeanor, domestic violence? This is a topic that I've written on in great length. There's a great article titled, "Why Can't Martha Stewart Own a Gun?" Right? If you were convicted of a white-collar offense and you spent a couple months at Club Fed, right? Are you really a danger to others so you can't defend yourself? So indeed, I think Robin, your question is on point. The status of constitutional rights after a person has been convicted of a crime is a very uneasy area of the law, and one which the courts have danced around. But your point's very well taken. That was a long answer to your question, wasn't it?
No, it's good.
Okay, thank you. Other questions? Yeah, Tariq.
Okay, how about the argument of the original framers that they intended that the women should not vote because most states at that time when they drafted the Constitution did not allow women to vote, so they said, okay, they were silent about it. If you wanted to say it, they would say it.
I'm so glad to that. So actually, at the time of the framing of the Constitution, that isn't exactly true. A number of states allowed single women to vote. Once they were married, they could not. So actually, this is my lifelong mission to find this. But at the time of the framing, unmarried women who owned property in New Jersey could vote. I keep wanting to do this and never find the time. But I'm convinced that at one of the constitutional conventions in New Jersey, there's a woman. I can't prove it, but the fact is, if they were able to vote at one of the local conventions, at some point a woman voted. There's probably no record of this, but it was at least feasible that it happened. So that's not entirely accurate, but for the most part, textually they're probably right. The 14th Amendment references males voting. You need another amendment to get there. And in terms of originalism, that's probably the better argument. But indeed, the 19th Amendment was ratified. Other questions on Minor or Bradwell? No? Go once, twice. Okay. So the next case we'll cover is called Strauder versus West Virginia. Okay. This is one of the cases, I'm sorry. This is one of the few cases that we'll cover where the government lost. In virtually every single case we'll cover between now and Brown versus Board of Education, the government won. That is, the segregation policy, whatever it was victorious. This case from 1880 was one of the rare, and I mean rare cases, where the government won. And before I jump into the facts, I want to put you guys in the right frame of mind first, if I may. It's very easy for us to look back 125 years later at these decisions and say, man, why couldn't the Supreme Court rule in favor of the person who was discriminated against? But you have to ask yourself a separate question. Had the court ruled, let's just take Plessy versus Ferguson as an example, easy one, right? Had the court in fact ruled that the train cars would require it to be desegregated, right? You have to integrate the train cars. Does anyone think for a moment that the people of Louisiana in 1890 would have listened? No. No. We discussed in the first week of class the Little Rock Nine, right? Where there's open defiance in Arkansas to try to desegregate the schools. That was in the 1960s. You had a governor basically stand on the steps of the schoolhouse doors blocking entry. Had the court ruled in the 1880s, 1890s, 1900s, oh yeah, Louisiana, go integrate your railroads, they would have laughed and ignored the courts. Okay. What does it do to the courts when they issue rulings that no one listens to? I think I've asked this question before. Why do people follow courts? Once a governor decides to ignore the courts, and then the president doesn't send in the National Guard, then the courts become a joke. Courts become a joke. So lurking in the background of these decisions, and you'll see it, is a recognition by the judges of saying, oh, this is probably really bad, right? But if we rule in favor of the plaintiffs, they're going to ignore us anyway, so yeah. But the flip side to that is, indeed, there's a very strong alternative argument. And you'll see this in Justice Harlan's dissent in the civil rights case, is that the courts are basically sanctioning injustice. And it's indeed one thing for the court to, make no ruling, right? It's another thing for the court to actually accept it. This is a Korematsu argument, right? It's one thing for the court to simply, not rule in the case, but it's another for the court to say, this is good, because then it sets precedent for the next generation to do something worse. Because Plessy was really the start of the segregation era. And after the green light was given in Plessy, the southern states ran with it, and they just expanded it. Louisiana was actually one of the first states to actually try to segregate the railroads. So as you read these cases, it's very easy to use your 20/20 hindsight goggles to try and ascertain, oh man, why can't they just rule this way? But keep in mind these two factors. One, had they ruled against the states, they would have been ignored, and the courts would have been made irrelevant. But two, they didn't just rule in favor of the states, they actually sanctioned it. They said, okay, separate but equal, that's a doctrine. Okay, go now apply it, right? They actually rationalized it. So I'd like you to keep those two competing frames in your mind. And I'm not saying one's right or wrong, whatever, but it's so easy to sit here in the 2016 and judge in hindsight a very different time without understanding the circumstances in which they were ruled on.
What prevented them from cooperating with like another branch? If they want to be taken seriously, why not? Like,
Do you think the president in the year 1890 would send federal troops into Louisiana to desegregate the railroads? We had just fought a civil war. Reconstruction was over, right? This was the big deal. After Reconstruction, the North pulled out the troops because we basically kept the southern states under basically federal supervision for decades. There was no other branch willing to send in troops. The fact that Eisenhower did this in the 1950s was remarkable, but there's no way. Most presidents before that favored segregation. President Woodrow Wilson segregated the military. I mean, there would have been no friendly audience in Washington. None. Other questions? Yeah, we have this vaunted image of Eisenhower saying the 101st Airborne. No way in hell would President Hayes have sent in federal troops into Louisiana or West Virginia to make them open their railroads up. It wasn't going to happen. You'll see this more in our readings for the next class. What I just said will make a lot more sense when you read the other decisions. Okay, where the court doesn't rule against the government, but doesn't bless it. They find ways of avoiding the ruling. You'll see what I mean next week. So the next case was Strauder versus West Virginia. Is one of the few cases which students like, yay, but it's one of the few. So there was a quote, colored man. And by the way, just another terminology. The word colored today has various meanings, but in fact, there's actually an improvement because the alternative was Negro. And actually, the fact that these were colored was actually, an improvement. But you'll use these terms throughout the lecture. So there's a guy named Taylor Strauder who was convicted of murder. He had an all-white jury. And the reason why he had an all-white jury was because the laws of West Virginia prohibited colored men from serving on the jury. Now, Strauder tried to have his case removed to federal court. Did you study removal in Civ Pro? Yes? We're laughing. So in theory, at least, if you have a case in a state court, you can remove it to federal court. So he said, listen, I can't get a fair trial in state court. Go put my murder trial in federal court. Now, that part of the argument probably didn't have any merit. But the main argument, he says, was the law limiting juries to white males violated equal protection. He didn't argue that he had a right to black jurors. He did not make that argument. What he argued was that the law itself, limiting the jury pool, the veneer, if you will, limiting the jury pool to whites was unconstitutional. It was a violation of equal protection. Now, when you take evidence, you'll study a case from 1986 called Batson versus Kentucky. B-A-T-S-O-N, Batson versus Kentucky. If a prosecutor starts striking out all the potential black jurors, you can raise what's called a Batson challenge. Wait a minute, you're just striking all the black jurors. So for many years, even after Strauder, even after jury pools were allowed to have blacks sitting in them, the prosecutors would just throw out all the black jurors using what's called peremptory strikes. So it wasn't until 100 years later, in 1986, that the court prohibited the practice of striking out jurors based on their race. And then this was later extended to striking out jurors because they're female. So the court here reads the 14th Amendment in a fairly broad fashion. The court says that under the law, everyone shall stand equal for the laws of the state. No discrimination shall be made against them by the law because of their color. Okay? So in a government courthouse, right, everyone stands equally before the law. People cannot be treated separately. The court writes, the very fact that colored people are singled out is a brand upon them, an assertion of their inferiority, and a stimulant of that race prejudice which is an impediment to securing to individuals of the race that equal justice which law aims to secure. So what they're effectively saying is not only is this law not treating people equally, but it brands them. By saying that blacks cannot serve in the jury, you're basically stamping them with what could be called a badge of inferiority, a brand, right? It's almost as if they call it a badge of slavery, right? Maybe you're not a slave, But by telling someone you can't serve in the jury, we're still treating you as a second-class citizen. And it's displaying to the world that you're a second-class citizen. And this is a symbol to others saying, ha, you can't serve in a jury, I can hate you. Right? When you see someone in a segregated train car or a segregated lunch counter or can't go to jury, you think less of them. So this law wasn't just meant to deny blacks jury service. It was actually meant to erect a literal separation, right? That people view them as a second-class nature. This is a common method during World War II, the Nuremberg laws, various methods of making Jews in Germany. They couldn't go to court. That's where various Jewish stars on their clothing. It was meant to see that they're less, and then it makes hate easier, right? When the state gives someone this sort of ridicule, it makes prejudice much more facile. So the case, though, was actually fairly limited. All that was held in this case was that the state could not have a law that on its face limited jury service to one group. Everyone must have access to jury service. Okay? The court says the law shall be the same for the black as for the white, and all races shall stand equal before the laws of the state. They shall stand equal for the laws of the state. But again, as we'll see, had any blacks actually showed up for jury duty, they would have been struck out. And it wasn't until Batson 100 years later that was actually addressed. Okay, questions on Strauder? Yes, ma'am.
So were they not doing that in federal courts? They were, is he wanting to remove his case to federal court?
Federal courts were better, okay, but they weren't perfect. The reason why I don't think his case can be removed is that federal courts don't have jurisdiction over state criminal matters. Right? The reason why you can remove a case from state court to federal court is that there's some sort of federal issue. Was it United Mine Workers versus Gibbs, whatever that case was, right? The common nucleus of operating fact, all that jazz. There was no federal issue here. The only federal issue was whether the individual, whether his constitutional rights were being violated. And that's the only reason why the case can go from the West Virginia Supreme Court to the U.S. Supreme Court. Other questions? I want to focus on the last words that I just read to you. All races shall stand equal before the laws of the state. After Strauder, they read that provision quite literally. The 14th Amendment would be limited to the laws of the state. But what about private action? What about private discrimination? Okay. And this brings us to the civil rights cases, right? It was actually a series of cases that were consolidated from across the country called the civil rights cases. And the civil rights cases consider the constitutionality of the Civil Rights Act of 1875. So recall, there are many civil rights acts we've done. We did the Civil Rights Act of 1866. We have here the Civil Rights Act of 1875. And you recall, we did the Civil Rights Act of 1964. This prohibited the racial discrimination in the Ollie's Barbecue case and the Hearts of Atlanta case. There are a lot of civil rights acts. I think, Scalia had a joke saying that, what was it? I don't want to screw it up. It's like, if you call something the Civil Rights Act, it could be anything, right? What? I don't want to screw it up, but it was a good quote. It was a funny joke. What was it? I'll try and find the quote later, but the gist was, if you call something the Civil Rights Act, no one can ever vote against it. No matter what's inside of it. I can't find the quote. I'll find it later. Okay. So the Civil Rights Act of 1875 was concerned with not just equal protection before the laws of the state, but equal protection in private places. So unsurprisingly, throughout the country, and not just in the South, throughout the country, various places of public accommodation were segregated. So, for example, in New York City, right, not Georgia, New York City, this was the Grand Opera House, which didn't let blacks in. Okay, I have a picture here. This was in San Francisco, again, not South Carolina, in San Francisco. This was McGuire's Opera House, which again had segregated seating. The Civil Rights Act said, all persons within the jurisdiction of the United States shall be entitled to full and equal enjoyment of the accommodations of privileges of inns, public conveyances on land and water, theaters, other places of amusement, subject only to the condition established by law. Okay? And here's a key part. It's applicable to citizens of every race, regardless of any condition of servitude. So if you read that, right, you would think that it provides that private places of businesses are not allowed to discriminate on the basis of race. Wait a minute, Josh, you're asking. Wait a minute, didn't we do this case in the 1960s? Right? Hearts of Atlanta Motel and Katz and Vacuum McClung. Didn't we do those cases? Like how they had to pass this act under the Commerce Clause to prohibit racial discrimination? The reason why it took another 90 years for Congress to enact a law prohibiting discrimination in private places was because of this case. In the civil rights cases, the court held that the Civil Rights Act of 1875 was unconstitutional. The court held that the Civil Rights Act of 1875 was unconstitutional. This case effectively crippled Congress's power to use its Section 5 authority to go after private discrimination. You may recall that in Hearts of Atlanta, the court addressed that some in Congress thought that the statute was justified by the 14th Amendment. Go back and check your notes, but it's there, I promise. In the Hearts of Atlanta case, some of the members of Congress said that this is justified by the 14th Amendment. That under their Section 5 powers, Congress has the authority to enforce the equal protection of laws. The reason why the Supreme Court relied on the Commerce Clause and not the 14th Amendment is because of the civil rights cases. In the civil rights cases, the court held that the 14th Amendment does not place any limits on private action. The 14th Amendment does not place any limits on private action. It only imposes limits on state action. So because the 14th Amendment doesn't limit private action, Congress has to exert its commerce powers in order to regulate private businesses. The only way to justify the Civil Rights Act of 1964 was the Commerce Clause. However, as we'll see in this case, that's not necessarily the right answer. Indeed, there's actually a plausible argument advanced by Justice Harlan in his dissent that Congress intended the 14th Amendment to reach not just private action, but state action. Okay, so any question on the frame of the case? Yeah.
Is that the case that you meant when you said that there were certain circumstances that the court had to rule in this direction, the government would not go?
Let me ask you. Had the court ruled in favor of the Congress in this case, what would have happened?
Nobody would force.
So there's a very good chance that had in 1870 the court ruled that Congress can prohibit all of this, private discrimination, they would ignore Congress. I think that's probably that. Any other questions before I start the case? All right. So to start the case, we look to the 14th Amendment. We look to the text. Okay. And it says here, The key word. No state. No state shall deny privileges or immunities. No state shall deny due process. No state shall deny equal protection. No state. Contrast this with the 13th Amendment. 13th Amendment says, slavery shall not exist, period. We said before, the 13th Amendment controls not just state action, but private action. No one, no individual, no government can hold a slave. Go back to the 14th Amendment. The 14th Amendment almost certainly does not cover individual action. It only covers what's called state action. Make sure you put that in your notes. The 14th Amendment only covers state action, the action of the states. It does not focus on the acts of individuals. Okay. So then what becomes the problem here? This is almost Zach's question before, but the court says if we allow Congress to do this, they can interfere. They can interfere with local governance, right? How a state decides to allow business to operate was historically a function of state law. And the court is not comfortable giving that authority over local municipal law to the Congress. Right? And here comes the important part. Only government can deny civil rights. The court holds that civil rights cannot be impaired by the acts of individuals. A wrongful act of an individual is a private wrong. An individual can't deprive someone of the right to vote, can't deprive someone of the right to hold property, can't deprive someone of the right to buy and sue. People can commit crimes, but unless they're acting under the color of state law, there's no constitutional issue here. So with the exception of slavery, right, none of us can violate the Constitution. According to the majority, the only way any of us can violate the Constitution, unless you're a federal employee or state employee, which I'm not, the only way any of us can violate the Constitution is by holding a slave. That's it. Okay? That's it. So any questions in the majority? We'll get to the dissent in a minute. Any questions in the majority opinion? The court adopts this view, and I'll read this at some length. When a man has emerged from slavery and has shaken off the concomitants of the state, there must be some stage in the progress of his elevation where he takes the rank of a mere citizen and ceases to be a special favorite of the laws. And when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. Okay? Mere discrimination on account of race are not badges of slavery. So if the court says here, and we'll see this message repeat throughout the course of the semester, is that, listen, we gave the slaves the 13th Amendment. They got the right to be free. We gave the 14th Amendment, whatever that was worth. The 15th Amendment, now you have the right to vote. Move on, right? No longer does the Constitution need to afford them any additional protections. That we've arrived at the state we should be at, and it's up to the democratic process to fix it. Let them vote for whomever they wish. They can vote, and they're not slaves. They can do what they wish. We'll see similar arguments when we discuss affirmative action in a couple weeks. The idea is this, that even if there's a Civil Rights Act and there's desegregation, everything else, that certain people are still at a disadvantage. And affirmative action is meant to remedy that advantage. And the counter argument says, when does this end? The case of Bruder versus Michigan. In 2003, Justice O'Connor famously wrote, and this was somewhat tongue-in-cheek, in 25 years, we may not need affirmative action anymore. So now we're 2000, so we're 13 years in. But did she actually mean that? And she since said she didn't actually mean that, which is easy enough to say now. But the idea of at what point special treatment end is a theme we'll see recur in a lot of our cases involving race. So it's, curious that in the very first case in 1870, whatever this case was, this exact issue pops up. Okay. Any questions on the majority opinion in civil rights cases? No questions? All right, let's move on to the dissent. The dissenting opinion is authored by a justice who I'd like to dwell on for a minute because he's a favorite of mine, an icon perhaps. So this is Justice John Marshall Harlan I. His grandson was also a justice named John Marshall Harlan II, which is a pretty good bloodline. Justice Harlan was he was a citizen of Kentucky, and he started off as in favor of slavery, although he came around later in life to abandon it. He actually studied law at Transylvania University in Kentucky, not like Dracula. And he was a very, very brilliant man. One of the reasons why I could say this with some authority is that while he was a justice, he taught constitutional law to night students at George Washington University. Can you imagine? Right? You're stuck with me. The kids at GW, right? They had for their ConLaw professor, Justice Harlan. 1 year, two of his students took out to transcribe his lecture notes verbatim. There was no recording back then. There's no YouTube, right? So they recorded every single word he said. And later on, they actually had it typed up and sent to him. Those papers were later deposited in the Library of Congress. So when I was in law school, one of my projects, and this is something I'm proud of, was transcribing all of those lectures. I actually went to the Library of Congress, and I took a picture of it. You can't scan. Take a picture and you just flip it over. It was like a binder this thick. And I actually published all of his lecture notes verbatim. I actually used some of his tricks. You'll never know which ones, but there's some things I say I get straight from him. For example, his discussion of the Supremacy Clause as the most important clause in the Constitution, that's from Harlan. He's exactly right. But he would lecture on end for 2 hours with a single scrap of notes. It's remarkable. He would go every single class, 2 hours without a scrap of notes. And he would often say to his students, I think I use this one also, no one should ever graduate law school without reading the entire Constitution cover to cover. I said that, right? It's from him. And he would always say, go to the local store for the price of price of a newspaper, you can go buy a Constitution, he would always say. You encourage his students. He also taught the Constitution not by cases, but by clauses. He would teach it sequentially. He would start with the Declaration, I guess I did the same, go to the preamble, then do Article 1, Article 2, Article 3. He very rarely ever mentioned cases. Although occasionally he would discuss pending cases. He would say, well, this case is under consideration now, so I can't really talk about it. And then after the case was decided, it's like, see, I told you about it. But he would always tell the students how he would decide cases. It's actually kind of crazy. And there's some pretty significant cases he would tease as well, whatever. My favorite line, though, was he would describe a case he was in dissent. And at the end, he would say, but, I was in dissent, so that means I was wrong. I was in dissent, that must mean I was wrong. And he was mostly joking, but he had a very good nature. So Justice Harlan is often known as the Great Dissenter. And he authored two significant solo dissents in this period. The first you read today in the case of the civil rights cases. The second you've probably heard of was in a case called Plessy v. Ferguson. Justice Harlan was only one to dissent in either case with 8-1 decisions. And Harlan, you'll see this in Plessy, evinced an ability to see beyond. He had a great perspective to understand where the law was headed. And he had a great insight of how to read the Constitution because he was so deeply studied. He so deeply was enmeshed in it. He would always say, let me read a page of the Constitution. He would just be ecstatic. You can see it from his notes. So Harlan's dissent in this case says, listen, you guys are nuts, right? We fought a civil war not just to give people sub-treasuries, right? We fought a war not just to give people, access to the jury system. We fought a civil war to have equality. And what's interesting with Harlan's reasoning is he reads the 13th Amendment, right? He understands the 14th Amendment won't get state action. I'm sorry. He understands the 14th Amendment is only limited to state action. So he says, but wait a minute, the 13th Amendment, and this is almost Robin's question from before in a different respect. He says, the word slavery is not defined in the Constitution. So he says, I'm not going to limit slavery to actual slavery, right? I'm not going to talk about actual bondage. Instead, he describes this thing called the, quote, badges of slavery and servitude. Badges of slavery and servitude. Okay, what are these badges of slavery and servitude? Think of them as things that remind you of being a slave, right? If you ever saw the Scarlet Letter, right? Hester Prynne has to wear the Scarlet A on her clothes at all time. That way everyone will always know she's an adulteress. Or I mentioned Nazi Germany. You would have really a star on your lapel so people know you were a Jew. To Harlan, by having these segregation laws, it was a reminder of slavery, right? Even if an African American was free and had all other civil rights, the fact that he couldn't enter the same restaurant or the same opera house told the people, okay, he's still a slave. So Harlan would read the 13th Amendment very broadly of not just actual slavery, but the badges and incidents thereof. Harlan also made another argument that was surprisingly not mentioned by the majority, that of common carriers. So I'm sure you studied in torts and elsewhere. Under the common law, if you were a common carrier, that is an inn or a hotel or a restaurant, you had a duty to accept everyone. Even though you were a private place of business as a common carrier, you had a duty to accept people because you were given basically a monopoly by the state. If you were a railroad, the state gives you a monopoly. So indeed, this could have been a way to address Ollie's Barbecue or the Hartsville Anthem Hotel. These are common carriers. But from what I can research, the government did not want to base the entire civil rights cases on common carrier doctrine because that could be changed by common law. So Harlan says, look, these places, they're not really public. They're private. I'm sorry, they're not really private. They're public. Okay. He then goes on to say, even then, I wouldn't limit the 14th Amendment to state action. He would read privileges or immunities broadly, and he would say the Congress has the power to enforce various civil rights. This part of his opinion is actually wrong. The other part's, is not necessarily wrong, but the 14th Amendment does limit the state action. This part he kind of flubs a little bit, but it's still okay. We'll forgive him. He ducks the Commerce Clause issue, but he actually references what winds up happening, right? His opinion basically foresees that Congress will exert its commerce powers to regulate these private businesses. And indeed, that's exactly what happened 70 years later, the Civil Rights Act of 1964. Okay. Harlan closes with this somewhat interesting discussion. He says, after they emerge from slavery, at some stage, they cease to be the special favorites of the law. But that is not the case today. The one purpose of this law is to enable the black race to take the rank of mere citizen. So the majority says after the 14th Amendment, boom, they're equal citizens, donezo, right? But Harlan's saying we're not there yet. And until that happens, right, Congress can take appropriate legislation. They can make appropriate legislation to make the equality of the races. Maybe at some point in the future, the situation will be different, but not today. All right, question on Harlan's dissent. Again, I apologize for lecturing, but even though I got through 5 minutes left. Questions on Harlan's dissent. Pay attention to Harlan's dissent when we do Plessy next week. There will be some surprises for you, which I'm sure you'll read and go, oh, I won't spoil the surprises, but there's surprises in there. Any other questions on Harlan's dissent, on civil rights cases, on Bradwell, on Slaughterhouse, on Strauder? No? I hope all of your colleagues finish your summary judgment motions. Okay. Have a great day. Thank you.